Something else that I want us to draw from the Martin Nyaga Wambora case, how to frame charges for an impeachment motion, because the Court of Appeal also dealt with that question. And when you look at paragraph 44 of the Martin Nyaga Wambora decision, the 2014 Court of Appeal decision, that's what I have in mind. If you look at paragraph 44, you will see that the Court of Appeal draws similarities in drawing charges for an impeachment motion to drawing criminal trial charges for court. In fact, the court uses an example of how to draw a charge of robbery with violence in trying to explain how specific a charge for impeachment should be. I say this because in drawing criminal trial charges, there is a wrong in framing charges called multiplicity of charges, and I'll show you how that wrong applied in the trial of His Excellency Rigathi Gachagua. Then finally, for the High Court jurisprudence, I will refer you to the High Court decision in Honorable Mike Sonko Mbuvi, Gideon, and Okia Omtata versus the Clerk, Nairobi City County Assembly. These were two consolidated petitions. And I will draw your attention to paragraphs 257 through 259 of that judgment of the High Court. For ease of reference, I will refer you to the various aspects of the impeachment motion that is in volume number 1 of the petitioner's document from pages 1 to 209. Look at that volume. And I'll refer you to the Hansard proceedings of the Senate. You'll find the Hansard proceedings of the Senate in the documents filed by Mukele Moni advocates in the CTS that are labeled Parts 5 and Part 6. Part 5 and Part 6. In Part 5, you will find the Hansard of 16th October 2024. Then in Part 6, you will find a continuation of the Hansard of 16th October 2024 and the Hansard of 17th October 2024. That Hansard is also referred to in the affidavit of my very good friend Jeremiah Nyegenye as Annexure JN 10 at paragraph 31 of that affidavit, which was sworn on 21st October 2024. So, returning to the question under scrutiny from my end, I would invite you to look at page 59 of the Hansard of 16th October 2024. This is now the page of the Hansard itself, not the page of the bundle, because my learned colleague, Mr. Mukele, did not paginate the full bundle. So you look at the page of the Hansard itself. Something very interesting happened. I want to paint the picture so that I abridge on time. Before the trial of His Excellency Rigathi Gachagua at the Senate issued a trial schedule, a schedule of the proceedings. The National Assembly had given the Senate a list of 5 witnesses. His Excellency, the Deputy President, had submitted his affidavit alone as his own witness. So the DP side had one witness, being the DP only. The National Assembly presented 5 witnesses. When the schedule came, the schedule gave the DP's team 2 hours to cross-examine the 5 witnesses of the National Assembly and 3 hours to lead the evidence in chief of the Deputy President. The Deputy President's team took the view that it did not need 3 hours to take their witness in exam in chief. This is their own case. They suggested to the Speaker that we need these 3 hours for our exam in chief and perhaps the 3 hours for our cross-examination of the National Assembly witnesses and perhaps the 2 hours for our exam in chief. So we are not taking any more time of the Senate. We're just reordering our own time, the one you have given us. At page 59 of the Hansard of 16th October 2024, the Speaker dismissed that literally by way of the hand. I mentioned three significant trials that have shown me that when these kind of things happen, it means there is malicious compliance. We are simply going through the motions. No one is asking for any more time. We're just saying of the time you have allocated us, we have a lot more duty in cross-examination. Give us more time towards that. We have lesser duty in exam in chief. From our own time, give us less time on that. It is judicially noticeable that the Speaker of the Senate is a lawyer of many years standing. It cannot be that he didn't understand the injustice inherent in the disproportionality in that time allocation. It cannot be he didn't understand. He understood it by virtue of the trust bestowed upon him as a trained lawyer. He breached that trust. Allow me to then very briefly take you through the various grounds of impeachment as set out in the motion and the evidence, what the evidence revealed in respect of each of those grounds. I will start with the ground number 4 of the impeachment motion. The particulars of that ground will be found at paragraph 34 of the motion itself. The particulars of ground number 4 will be found at paragraph 34 of the impeachment motion. This is one of the grounds that the Senate approved and which contributed to the loss of office of His Excellency Rigathi Gachagua. The particulars state that the Deputy President made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition against the said judge in gross violation of Article 160, Clause 5 of the Constitution. It is a requirement in impeachment proceedings that the impeaching house cannot introduce any new grounds at the Senate stage. They are held to account on the grounds as approved by the National Assembly. The ground was that the Deputy President made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court, and falsely threatened to file a petition against the said judge in gross violation of Article 160, Clause 5 of the Constitution. So a number of things are important, my lords, my lady. One, what does Article 160, Clause 5 of the Constitution provide? it provides that a member of the judiciary is not liable in an action or suit in respect of anything done or omitted to be done in good faith in the lawful performance of a judicial function. It's not liable in suit. You can't take them to court. If you look at ground number 4 and particulars of paragraph 34, it is alleging that the threat to take a judge to the Judicial Service Commission is a violation of Article 160, Clause 5. I wonder, their lawyers are here, they will tell us. In fact, some senators are actually here, they will tell us. How does Senate read Article 160, Clause 5 as against Article 168, Clause 2? Because Article 168, Clause 2 constitutionally gives any person the right to initiate a petition before the Judicial Service Commission for the removal of a judge. So if you state that you are going to pursue an Article 168, Clause 2 process, how can that be a violation of Article 160, Clause 5? I was taught many years ago, I hope it's still learning today, the Constitution is not self-annihilating. We cannot read Article 160, Clause 5 to destroy Article 168, Clause 2. So that the National Assembly brought a case to the Senate that a claim by the Deputy President that he is going to file a petition against Justice Esther Maina is a violation of Article 160, Clause 5. The Senate approved that ground for removal of the Deputy President. Now, let's not lose focus of this, my lords. The express text of the ground and the particulars at paragraph 34 of the motion is that the Deputy President had falsely threatened to file a petition against Justice Maina. Now, the Supreme Court has told us the ground must be substantiated. So I will now take you how the motion mover substantiated the ground. If you look at page 60 of the Hansard of 16th October 2024, so on the attached the affidavit of Jeremiah Nyegenye as Annex J N10, the following conversation takes place. The motion mover is being cross-examined by yours truly. The Hansard of the Senate captures me as asking this question: do you still stand by that part of your allegation that he has not presented the complaint to the Judicial Service Commission as at that date? The motion mover says, I have since learned that he did present the petition. The motion mover is conceding that his claim in the motion that the Deputy President falsely threatened to file the petition cannot pass muster. Yours truly, my lords, then suggests to him that to the extent that you say that he has not presented the allegation to the JSC as at 26th September 2024, that allegation is not true. Is it? The motion mover says, we are in agreement, counsel. The motion mover concedes that the ground on which his motion is founded, ground 4, cannot be substantiated. With this Hansard before them, members of the Senate voted to approve this ground. Can it be said that in view of this concession by the motion mover, that ground had been substantiated, that it passed the threshold? The third aspect I want my lords to reflect on when you retire, you can answer this question either way. Some of us enjoy reading these judgments either way. But I want direct answers to these questions. judge has had a case and delivered a judgment and become functus officio, can a verbal criticism of the manner in which that judge conducted herself in that case constitute a violation of the decisional independence of the judge? That's what the ground said. It said gross violation of Article 161 of the Constitution on the institutional and decisional independence of judges. Can a verbal criticism of a judge, because of a decision she has already rendered and become functional official, amount to a threat to the decisional independence of that judge? Which decision? She has already rendered the decision.